Good afternoon. Welcome to the second in a four-part webinar series where we are tackling the implications of professional licensing for condominium corporations, including self-managed condos. My name is Heather Coleman. I'm a managing director of the Alberta Real Estate Association and a board member of the Alberta Condominium Management Education Consortium, or ACMEC. ACMEC is a Canadian not-for-profit joint venture between CCI North Alberta, CCI South Alberta, and the Alberta Real Estate Association. ACMEC was created to offer high-quality condominium management education for industry professionals by industry professionals. I would like to acknowledge that Alberta is the traditional and ancestral territory of many First Nations, Métis, and Inuit peoples, and express gratitude for the traditional knowledge keepers and elders who are still with us today and those who have gone before. We make this acknowledgement as an act of reconciliation and pledge to address systemic racism. I would also like to take this opportunity to thank the Alberta Real Estate Foundation for their generous grant that enables us to deliver this series without charging. For more information on the work that ARIF does, please visit their website at arif.ab.ca. For those of us in the Alberta condominium community, the implementation of condo manager licensing has generated a lot of questions and caused uncertainty. This webinar series was developed to be a resource to condo boards, managers, and owners. We are hosting experienced subject matter experts who provide their insights about what licensing means for the condo community, answer arising questions, and inspire certainty in a newly licensed industry. If you like what you see today, please make sure to register for the rest of the series. Still upcoming, things to know for self-managed condos on August 9th at noon, and the RECA disciplinary process on August 30th at noon. Now to a few housekeeping reminders. Audience cameras are off and microphones are muted unless prompted by the host. Please type your questions in the Q&A panel and keep all chatter polite. Questions will be answered at the live Q&A following the presentation. We are recording this webinar and we will share the recording link with all participants. We will also be sharing the recording on the ACMEC website so it can be accessed into the future. With that, we are pleased to bring you the expertise of broker Andrew MacLachlan and lawyer Sandy Cameron, both from Calgary. Over the next hour, Andrew and Sandy are walking us through a look into statutory changes, the practical considerations of the condo manager licensing process, where we will learn more about the new requirements for service agreements and expected financial implications of licensing. Before we get started, let me share a little bit more about our presenters. Andrew serves as Regional Director for FirstService Residential. In this role, he is responsible for supporting community managers in their daily operations, while also ensuring that all on-site staff are delivering exceptional service to condo boards of directors and residents. Andrew possesses extensive experience with strategic planning, contract negotiation, cost containment, and contract and vendor management. As a leader in corporate services within the commercial real estate sector for over 30 years, he has a proven record of providing customer-first solutions. Before joining FirstService Residential, Andrew was General Manager Western Canada for a publicly traded real estate investment trust. Andrew holds a B.Ed from Concordia University in Montreal and is a licensed realtor and broker of record for FirstService Residential in Alberta. An astute and highly respected lawyer with over 45 years experience, Sandy Cameron ran an active practice in Calgary at Horne Law Office, dealing mainly in small business, condominiums, and land-related matters since 1993. Semi-retired since 2007, Sandy maintains a small practice for select clients. He has served in senior volunteer capacities on many boards, with one of his most notable accomplishments being the founder of the Calgary Home Builders Foundation, a not-for-profit charity constructing affordable housing projects for those in need in the Calgary region. Sandy has received numerous awards for his visionary and forward-thinking engagements, with the ultimate being the Maple Leaf Award for the greatest contribution by a non-builder member from the Canadian Home Builders Association. Sandy is also one of the first members of the Alberta Home Builders Hall of Fame. And with that, I'll hand over the reins to Andrew and Sandy to take it away.
Good. Thank you, Heather, and thanks to ACMEC and everyone who's been involved in putting this together, this series together. We appreciate you inviting us, and we look forward to the next hour with everyone who is on the call. So I'm Andrew MacLachlan, and you know, my role to kick this session off is to outline what we're going to talk about over the course of the next hour. I'm going to preface that by saying that there's a lot to cover. And we may or may not get through the entire presentation today. The good news is some of the information at the latter end of this will be covered in greater detail in, I think, Dion Levesque's presentation in a week or so when we talk about RECA and consumers in more detail. So if we are running out of town, Bev and Heather, please give us the hook, and we will we'll move through that last part of our presentation fairly quickly. Today's speaking topic is around legislative changes, the statutory changes and regulations that have impacted the condominium property management industry specifically. This has had a very significant impact on our industry, which was unregulated essentially since its inception. And I want to say some of the first condos built in Calgary date back to the early 70s. And until 2020. You know, the property management industry essentially self-regulated. They ran their businesses as professionally as they could without oversight. And so the implementation through Service Alberta and the involvement with RECA and their oversight to protect the consumer has impacted both us, you know, as condominium property managers, as well as the corporations that we serve. Through the lens of the corporation responsibilities, corporations and those elected to be sitting on the boards of those corporations need to appreciate that as homeowners, they own an asset, but as board members, they're responsible for a significantly larger asset. This could be from several million to over $100 million easily. So there's a very significant corporate and governance responsibility that board members take on when they choose to provide oversight for their property. As Heather pointed out, this seminar is dealt to address both the self-managed property as well as the third-party property management component to it. We're going to be looking at it primarily through the lens of the third-party property management component, but happy to answer any questions anyone may have on the call at the end with regard to self-management. But the reason why I preface the value of the total or totality of the asset is to give people who are board members perspective that they do have significant responsibility. And while it may be a volunteer position, they cannot abdicate the responsibility to run the property to the condominium property manager. The agency relationship is quite well defined in that regard. There's a significant number of topics that we could cover over the course of the conversation today. And unfortunately, we've had to limit the number of key topics to the ones that you see on the screen right now. Essentially, we're going to talk to some changes that have taken place in the Real Estate Act itself, which is a completely separate act from the Condominium Property Act. The Real Estate Act, I call that one more transactional. It deals with commercial and residential property management. It deals with residential real estate, rural real estate, and the Condominium Property Act itself has been a standalone act, and the two now have been more closely aligned and linked under the new legislative process. So I'll speak briefly to the Real Estate Act, and Sandy will speak to the Condominium Property Act changes. Then we're going to move into the service agreement. One of the biggest things that has impacted the industry is the mandatory service agreement that must be in place between a service provider and a condominium corporation. And then Sandy will take on some conversations around responsibilities that the boards have for motions and resolutions and a few other legislative changes that have affect the governance approach and governance standards associated with managing a condominium property. And if there's time, we'll spend some time talking about RECA and consumers and RECA's role in protecting the consumer in the property management service of property management, the delivery of property management services. Sorry, I'm getting a little tongue-tied there, which means I've been talking too long about the agenda. And Bev, so we can move on to the next slide, which will be changes to the various acts, and I'll kick off with the changes to the Real Estate Act. There's already several bullets on here. For time, I'm certainly not going to speak to each and every one of these. Let's kick off with condominium managers must be licensed and bonded. In the past, as I mentioned, changes to the Real Estate Act, there was really no barrier to condominium property managers to provide services. This is not to say that condominium property management companies were not professional. It simply stated that there was no requirement to be licensed to provide a real estate service. Our survival within the industry, of course, is fully dependent on our ability to meet the expectations of our client. And big or small, big or small condominium property managers develop their own in-house training, recruiting, and service delivery models. The big change now, though, is that it is impossible for us to be able to provide community condominium property management services without first having a brokerage license, having a licensed broker to run that brokerage, and then having our associates who provide the property management services to be fully licensed. There are performance standards, which I won't go into a great deal of detail today, though happy to answer any questions at the end. There's a little bit of time set at the beginning for the hearing process and complaints. What's important to note here under these legislative changes is that there are pathways for the consumer, whether the consumer be our client, could be the condominium corporation and their board, or the homeowner or occupant within the building. There are now pathways beyond the courts. And RECA is a major part of that, and we encourage our clients to become familiar with what is available to them as a resource at RECA, and what the steps can be taken to ensure that we're being held to a high standard. Every year, our managers will be required to have a license in good standing, and while RECA has paused annual licensing training. Again, this is brand new. Most of the associates in the industry that are currently licensed are what we call conditionally licensed, pending the outcome of some education requirements. The practice of condominium management and the fundamentals of condominium management courses must be completed first. Every September 30th, those licenses need to be in good standing, and those licenses need to be renewed and paid for. As the title implies, what are some of the impacts of the statutory changes? Well, costs. This was a cost to condominium property managers that didn't exist previously and is there today. The roles from within RECA clearly define what the roles are for a condominium manager broker and the condominium manager associates, what services they can and cannot deliver, and what unlicensed associates or assistants can do to support a licensed manager, and what services can they offer legally, and which ones must they refrain from. Record keeping, again, most condominium property management companies have been following best practices when it comes to record keeping. Many of those are as guided by CRA, and in some cases through GAAP, generally acceptable or accepted accounting principles. But now they're more clearly defined in the Real Estate Act. In fact, there are 4 or 5 pages within the Act and the rules defining how long records must be kept, what's the method of keeping those records, who owns the records. These things are now more clearly defined and less open to dispute between condominium corporations and the managers that provide the services. There's a lot more defined timelines associated with transferring funds into and out of trust accounts, for instance. When we receive lawful instruction from our client, how much time do we have to ensure that contracts have been paid in a timely fashion, in that the funds that we've received from owners for their contributions, either for their condo fees, for their reserve fund contributions, or any special levies that may be associated with the property. Those are now much more clearly defined, and there are higher levels of expectation for condominium property managers to perform and deliver under those standards. And then contracts, and we'll go into more conversation about contracts a little bit later on under the service agreements. But the condominium property manager has oversight and responsibility of ensuring that all of the contracts that the corporation has been bound to, whether that be for preventative maintenance, for landscaping and snow removal, whether it be for plumbing, electrical, and any other engineering capital projects that need to be undertaken. These are things that we must keep a very close eye on, keep very good records for, and ensure access to this information for our client, either through a cloud-based resident or client portal or some other customer relationship management platform. So all of these things have been have always been in place for the Real Estate Act, for the transactional side of the business. For the condominium property side, these are all, the Real Estate Act has changed in a few key areas to link us more closely with the real estate world as condominium property managers, and the entire Real Estate Act is something that is new for condominium property managers to be familiar with, and to ensure that their in-house policies and procedures are aligned with the expectations of the Act. And this has been a big change for our industry to ensure that we have clearly defined policies and procedures as well that are aligned with RECA's expectations, to basically to keep us in line. So that's really the highlights. And obviously, both Sandy and I could go on ad nauseum about the Real Estate Act and the Condominium Property Act. When I looked at the original title under considerations for statutory changes, my immediate reaction was, wow, that's not the most exciting topic to talk about. But clearly we'll be here to answer a lot of questions. Hopefully there are lots of questions and make this a bit more interactive at the end. But those are the highlights of the Real Estate Act. And with that, Sandy, if you'll pick it up for the Condominium Property Act.
Sure. Thanks, Andrew. Just a quick comment on Andrew's. There's a curious discrepancy between the two acts when it comes to record keeping. If you are a property manager, there's a Real Estate Act has all kinds of provisions, everything from electronic to paper and how you keep them, store them, requirements. There is no similar requirement under the Condominium Property Act. So if you're a self-managed condominium corporation, you're just left with the general business practice requirement. Says you'll do what's reasonably practical. There are, certainly under the Condominium Property Act, there's lots of requirements of how long you will keep various documents. And that's clearly set out. But dealing with the Condominium Property Act itself, there is a theme to the amendments. And the theme really was that the government decided to deal with issues where they had been receiving complaints from owners, and they dealt with a whole number of them. So highlights, one of the first one, of course, is the notice period changed from 7 days to 14 days for calling an annual general meeting. That was an easy one. If you're something that is delayed calling meetings is now to call an annual general meeting or an AGM, you must attach to it the financial statements, which have now, and their requirements, how they are to be produced. You must attach reserve funds, a reserve fund report. That's a new document that's just got created under these amendments. It's essentially, here's what's coming up in the next year. Here's what happened last year. And you must accompany that notice with the budget. Because you have to wait for the financial statements before you can send out the notice, it has slowed down the ability to call an annual general meeting after your fiscal year end. So typically, you used to be able to do it within 60 days of year end. Now you're looking at 90 to 120 days because you have to have the audited statements before you can send out your notice. The rules relating to proxies have changed. They take a one sentence out of the old act and now multiply that out. It now covers about a page and a half. And it creates some problems. Proxies now have to be in electronic or hard form. They must be, the names of the owners giving the proxy have to be there, and the unit numbers. It must have a date, and you must name whoever's going to be the proxy. You can't, there's some question whether you can name an officer, i.e. I name the president or the chairman of the meeting as my proxy. That's likely permissible. It's not expressed, but it's likely okay. You cannot name a manager. You cannot name an employee of the manager as your proxy. Too many projects that were revenue type properties got abused on that one. We'll deal with electronic meetings later. That has its own peculiarities. Under the regulations now, you have to circulate the minutes of the AGM within 60 days of the end of the AGM. You remember the practice used to be the minutes for the AGM would be circulated with the notice of the next AGM. In short, you'd see the minutes a year later. No longer, now it has to be out within 60 days. It would be draft, of course, because it doesn't get approved until the next AGM. There's some requirements now that those minutes must include the results of votes. Now that's a bit of a change, particularly for directors. It used to be that the chairman would simply announce that A, B, and C were elected as directors, and thank you to D, E, and F for running, and that was the end of it. No longer. Now you must set out the number of votes for each candidate for office. And the old practice of saying at the end of the meeting, can we destroy the ballots used at the meeting, is gone. Ballot papers and anything used in the election must be retained for at least a year before they are deleted. There are new provisions in the Act for rules. The old practice was that you could create a rule, post it on the board, and away you went. No longer. Now, to put a rule out, you must draft it, you must send it out to everyone, and it becomes effective 30 days after you've sent it out. There's an exception there if it's a safety issue. If there's construction going on, you can post a rule immediately saying, do not use this entrance, effective immediately, if it's a safety-related issue. But otherwise, it's stalled. Old rules got deleted unless they were renewed and approved under the new system. And if you put a rule together during the course of the year, the rule will be enforced 30 days after you've done it, as long as it is approved at the next AGM. If it's not approved at the next AGM, then it ceases to be effective. There's an extensive changes to the whole issue of levying fines. A manager no longer has the ability to levy a fine if there's a complaint, there's a breach. If there's going to be a fine for something, it must be authorized in the bylaws, not in a rule. The authority must come back to the bylaws. And you don't have to set the amount in the bylaw, but the type of conduct has to be set in bylaws in order for it to be effective. The board must send to the owner affected a preliminary notice that they're going to levy a fine and give that owner an opportunity to respond. The board, and not the executive, the board must consider the response and then proceed either to wipe it out and forget about it if the defense is a good one, or if it's not, or there is no response, then proceed to levy a fine. There are limits on what you can levy as a fine. $500 for a first offense, $1,000 for second and subsequent offenses. Or there's a curious provision, or a lower amount if it's set in the bylaws. So you may want to check your bylaws. If you have an old set and it had a fine of $25, then it's the lower limits that apply. Those are the main changes coming through. Then we go from there. There is, when the pandemic hit, of course, all the boards were scrambling, trying to say, how do we call an annual general meeting when we can't have a meeting of people? And there were all kinds of alternatives tried. Can we do this as resolutions in writing? Can we do virtual meetings? But there was no authority for an electronic meeting. So there was a fast amendment made to the Act that inserted electronic meetings. And the thing to note here, this is one of the few areas where the bylaws can override the statute. So the provisions for electronic meetings are subject to any provisions to the contrary in your bylaws. And you should now go back and look at your bylaws and consider putting some limits in to control electronic meetings, or eliminate them entirely if you wished. And that may come back to the size of your condominium corporation. If you're a small corporation, electronic meetings may be a wonderful way to go. But if you're a 200 plus condominium corporation, it's awkward, it's difficult, and it has its own particular problems. Andrew, I think you have more experience on the day-to-day running of those things than I have. Can you chip in a bit?
Yeah, one of the key considerations that we have to keep in mind in the changes in the incorporation between the two acts and the legislation and the licensing, that there are these legislative changes effectively mandate a way for a corporation and for property managers to deliver services and to perform their duties. A smaller property, 4, 6, 8, 20 units perhaps, is a little less complicated. AGMs are a little bit more simple. Sometimes they're just done in person in the courtyard. We know through experience, attendance generally to AGMs can be quite low. An 18-unit complex might only have 4 or 5 people show up. So a little bit easier. So when I speak to some of the more impactful aspects of electronic meetings, I'm really speaking of it through the lens of 75 units, 100 units, 500 units, 1,000 units, where AGMs can be attended by a very large number of people on a proportionate basis to the size of the complex. And as Sandy pointed out, any owner who is in good standing can choose to insist to attend only through electronic means. And if only one owner attends through electronic means and there are several hundred people attending the AGM, we're now balancing people that are live in the audience. There's a registration process, there's scrutineers, there's elections, there's motions, there's voting, and then you've got folks that are online, 1, 2, 3, 4 people, and they cannot be ignored as part of the process. And so one of the things that we've encouraged is corporations engage a third party. It's like everything else that we do. Property managers have a great umbrella or a great toolkit of resources available to them, but we're not experts in everything. We're not lawyers, we're not accountants, we're not project managers, we're not engineers. And we're also not the best facilitators for very large AGMs to keep track of all the moving parts. So we do recommend now that corporations hire third-party agencies like Get Quorum and other teams and companies that provide services either through Zooms or through Teams or other methods, who are professionals at keeping track of all the details. We're not going to go into details about what all those are and break it down in terms of the governance structure of an AGM meeting, but please note that if you are a larger condominium complex and you're working through an electronic form of meeting, the cost associated with engaging these third parties is scaled based on the size. The bigger the meeting, the more it costs. And the amounts can be several thousands of dollars. Medium-sized company could be $1,500 to $2,000. A large one could be $3,000 or $4,000. And so when you're planning your year for your budgets, and we as property managers are guiding our clients through planning their year for the budgets, it's important for us now to keep track of this as a specific line item because it is a significant one-time expense for this event. Tack that on to all the mailing costs associated with getting the notices out, because it can go out electronic or it can go out in hard copy, and et cetera. So it's a big impact financially, and it's something that corporations and property managers need to be mindful of when they're planning for the year ahead.
And that brings us to,
yeah, segues us to costs, I think I introduce you here, Sandy, real quickly. The notion of increased costs, the condominium, the way we're seeing the impact of legislative changes, both to the condominium property manager as well as to the corporation. The example of the electronic meetings and the impacted cost. The workload for condominium property managers and those that support them, the accounting team, the administrative team, and corporate services teams, has increased significantly. There's a lot more things that we need to pay attention to, that we need to provide guidance and advice to for our clients to ensure that they're in good standing. Sandy mentioned a few things in the legal discussion around the accuracy of minute taking, the accuracy of the proxy voting, et cetera. Someone needs to keep track of that. The corporate secretary generally is that individual, but many of the volunteers don't have the requisite experience to be able to be exceptional minute takers and to understand that if this isn't addressed at the AGM and voted upon, it could be dropped. So you have to reapply your rules or your notices and reinstitute communications with your owners to be able to legally be able to fine or sanction homeowners for violations. So I'd say that the biggest thing is increased workload and increased accountability. It will be the kind of overarching principle for the next few minutes. On that note, Sandy, do you want to kick it off?
There's a couple of, let me add a couple of other items in here that have a direct effect. One, of course, when you're sending out an annual general meeting notice, you're required to give the notice to any person who's entitled to vote at the meeting, and of course, any mortgagees who've registered their mortgages with the condo corps. You got to keep that record separately, make sure they get notices. But the other one is any person who is entitled to vote at a meeting. Well, that means anyone who's on the registered titles. Now, the practice is that most condominium managers or condo corps, if they're self-managed, maintain a register of their owners. Unfortunately, that register is not the one that governs. It's the one at land titles that covers, that is the governing document as to who owns the unit and is therefore entitled to notice. To be accurate, before you send out the annual general meeting notice or a special resolution or something else, You should do a search at the land titles office of all the titles in your condominium corporation in order to be able to ensure that the notice, I'm sorry, that the list of owners that you have is current and accurate, including the addresses for the owners. There's a cost attached to that. Land title's fee for a title is $10. If you go through a registry shop to get it, they're going to charge you an extra $2 or $3 a unit, I suspect. I don't know the exact number per unit. If you go to your property manager and say, hey, will you get this? You're going to pay more than that because their time gets factored into this. The unfortunate part of this is you would need to do this frequently. When you send out the notice of the annual general meeting, you should have an up-to-date search. If you're circulating a special resolution to amend your bylaws, again, you need to know who's, when you get all of the votes back, you need to be able to check that off to make sure that you, in fact, have the right percentage of persons entitled to vote. And remember, the distinction here, it's not, in a special resolution, it's not 75% of the units. It's 75% of those persons entitled to vote at a meeting of the condominium corporation. So you may have 30 units, but you could have 45 actual registered owners. And it's the registered owners that are critical to know. So.
And I would add, if I may, Sandy, I would add registered owners and lenders. You know, it doesn't happen very often. Lenders, Royal Bank, credit unions, they can register their right to be made aware of any events occurring at the property. And it's important to keep a very detailed ledger of those institutions who have registered their right to receive that information. And so it's not just the registered owners. It'll be those who also have a claim against the unit who have also registered their interest in knowing what's going on at the property that need to be informed.
Yeah, quite correct. But remember that for a mortgagee, they don't get notice unless they have notified the condominium corporation that they wish to have notices.
Correct.
And 40 years ago, just about every mortgagee did. Now, very few of them do.
Yes.
So that fortunately is a short list, but you don't need to go back and check their title to make sure their mortgage is still registered. Because you send the notice to the mortgagee at the address they've given you. There's another aspect that this has triggered that is increasing the costs. And partly this whole concept of rampant misinformation that's sitting out there. What we're finding is that condominium boards, when they call the AGM, are worried because they have a number of owners who seem to have a different view of the regulations or how a condominium operates. And they get owners who come back with some rather strange views on what boards can or can't do, or what the owners can or can't do. The end result of that has been that quite frequently a board is saying, we need to invite our lawyer to the meeting to offset the owner who stands up and says, this is illegal, this can't be done, or this requires a special resolution when it doesn't. There's a cost attached to that. You wish the lawyer to come to a meeting, you're between $500 and $1,000. So we also are finding that most bylaws provide that the president of the condominium corporation will be the chair of all meetings, but not all presidents are comfortable running a meeting. There's Robert's Rules of Order, of course, is, I don't know, 1,000 pages thick. But somehow we expect a volunteer president to know all the rules of running a meeting, etc. quite frequently now, particularly if they're anticipating a difficult meeting where there might be complicated issues to be dealt with. The end result of that often has been as boards come back and wish to have a, let me call it, professional chairman rather than a volunteer one, just to deal with the complexities that are there. There's a cost attached to that. Other issues, and this is not new and it's not governed by regulation. If you're dealing with a technical issue at a meeting, it's worthwhile, particularly if you're doing serious renovations to the common property, for instance. It is quite common now, invite the engineer to the meeting who's overseeing this, invite the contractor. So you've got the resource at the meeting to deal with the detailed questions that come up, because as a board, as the chairman, you can't be expected to cover them all. And there's nothing like an expert on the subject to shut down misinformed discussions. Otherwise, your meeting could run forever and get stymied. Yeah, costs are up, workloads are up. And that workloads are up. That brings us to service agreements. Back to you, Andrew.
I also just noticed a note that there's 19 minutes left in the session, and we definitely want, I see that there's at least a small handful of questions so far in the Q&A and in the chat. So we definitely want to leave some time for Q&A. So as I mentioned at the outset, I think Bev will skip over the RECA and consumer component of our discussion as we get there. And I'd say at the end of the discussion around service agreement, we'll call that the conclusion of the formal presentation aspect of this and move straight into the Q&A, if that's okay. With that, the service agreement. So we mentioned at the beginning, one of the biggest changes that has impacted the condominium property industry is the link back to the Real Estate Act. And in the Real Estate Act, people providing services for residential real estate, for rural real estate, commercial or residential property management. You've always had to have a service agreement in place, and it has to have been very well defined, and it has to have been properly executed. I'm not saying that prior to the legislative changes, condominium property management companies didn't enter into contracts. But I did mention that the barrier to entry into the industry was significantly less prior to the legislative changes, and smaller organizations would often just be engaged to perform a service, to provide some property management service without too many guidelines. And in some cases, though limited, no service agreement, essentially a handshake that, hey, I can manage your property for you. I'll just charge you X thousands of dollars per month, and these are the handful of things that I'll do. That has all changed, and the sophistication within the industry as well has increased quite significantly. So the importance of the service agreement, which essentially is the mandate that we as property managers receive from our client. So before we go into what are the elements of the service agreement specifically, I think the condominium corporation, for those of you that are sitting on boards today and are considering what you need to look for in a contract, and those of you that are providing the service, being mindful of to ensure that you're capturing when you're valuing your contract. There are daily, there are weekly, there are monthly, and there are annual responsibilities that a condominium manager must undertake and must be aligned with the corporation and the board on in terms of what their expectations are to deliver. On that note, Bev, I'd encourage you, just feel free to kind of, yeah, thank you, just like that, because I'm not going to go into a lot of detail about each one. But managers, I'd say one of the biggest thing, and the third bullet on the weekly responsibilities is emails. A portfolio manager with 8 to 12 properties, 1,000 to 1,500 doors, is going to get anywhere between 200 and 300 or more emails every day. So daily and weekly, it's just the constant communication that takes up the most amount of time. We're always being mindful of where we're receiving instruction from our client. and when we're having to deal with our customer. And in our world, the client is the condominium corporation, and our direct liaison typically is the chairman, and our customer is the resident. And we owe a duty of care and skill to both. We only owe a fiduciary obligation to our client. So we have to be really clear where we're getting instruction, what requests for services are coming through, and that on a daily and weekly basis, and a significant burden on the service provider. Monthly responsibilities are going to be, no, if you can just back to the other one, I'll close out real quick on monthly and annual before I jump into the actual contract. You're going to have monthly board meetings. Now, not every corporation has monthly meetings. Some are 3 times a year, 4 times a year, some are 10 or 12 times a year. Regardless, there are board meetings. Board meetings mean managers' reports, financial statements need to be prepared, reviewed, consolidated, and submitted in advance. We've got ongoing contract reviews that need to take place, being mindful of when utility contracts are going to expire, and especially these days, if you're not in a long-term fixed price contract, the variability of gas and electricity has had a major impact on our operating budgets with our clients. The same with your insurance and getting ahead of the curve and insurance renewals. These are things that should be part of a checklist and reviewed through the manager's report at each of the monthly visits. Site visits and the responsibilities of the manager and the corporation as it relates to taking place for site visits. And in particular, the spring walkthroughs, where we establish what the guidelines are going to be typically for the coming summer, especially for those suburban locations that are more apartment style and townhome who have large green spaces. And then the annual responsibilities. There's the annual audit, reserve fund reporting updates, and then the AGM and the presentations that go along with those. I encourage our managers after the AGM to ensure on an annual basis at the next meeting of the new board that 3 things take place: that the new board members undertake a review of the code of conduct that is expected of board members, and the interactions that they have with their representatives, whether that be the property manager or any other people providing service at the site. We very much encourage our managers to revisit the scope of services in the management agreement, because that is our mandate and that defines the services that we're going to offer, and then realign on what the meeting frequency and schedule is going to be for the coming year. So when you think of all of this in context, daily, weekly, monthly, and annual responsibilities, these things should serve to drive what your management agreement, what your service agreement, what the mandate is going to say. So on that note, let's talk briefly about what do we need to see in a contract. And again, Bev, if you just want to throw the bullets up real quick, that's perfectly fine. I'm not going to go into significant detail about each. Essentially, these bullets that are coming up on the screen, and Sandy can certainly speak to this much better than I can. There's contract law that is separate from what's written in the Real Estate Act. And it also has its own definitions and guidelines of certain minimum standards that you need to have in a contract. But the Real Estate Act itself as well outlines some of the things at a very minimum that you need to see in the service agreement or the mandate that you're providing to the property manager that you'll be engaging with. So obviously, the document needs to be signed. We don't need wet signatures. These can be electronic signatures. Document or software packages like DocuSign are brilliant and can expedite the process, especially since we interact so much more today than we did before in calls such as the one we're on today. The names of the parties need to be clear. In my case, FirstService Residential is not our official name. We need to have the official name of our company, and a condominium corporation is often primarily known by its condominium corporation number, and it operates as a business as ABC Condo Community. So we need to be really, really clear in terms of how the parties are defined and who the signatories are, and being extremely mindful who was authorized to sign on behalf of both corporations. We need to know what the property is and the location, where it is, and what its structure is. We need to have a start date and an end date. It cannot be an open-ended contract that just goes on in perpetuity. The services to be provided. This very much is something that is tied to my previous note. Understanding what it is that the manager does daily, weekly, monthly, and annually will drive what those duties of the manager and duties of the board are. And it's critical that you ensure that the scope of services that you're going to offer as part of your management fee are well defined, and that those that are ancillary, where you provide additional services, some of them may be providing services to owners who are looking to get info packages to sell their property. Well, those are charges that go direct to the owner or potentially a purchaser. But there are other services that we offer that are ancillary to our day-to-day management pieces, and those also need to be defined, and the amounts for those services need to be tabulated. Obviously, elements within the contract to respect confidentiality. We're governed by multiple statutes and legislations federally and provincially. PIPEDA and PIPA, the duty to protect the information of our client and the residents. These things should be defined, and then obviously the confidential nature between the parties. And then provisions for the parties to get out of the contract in the event of performance or non-performance of services throughout the term of a contract, which could be anywhere from 1 year to 2 years to 5 years, and then provisions for cure. So essentially, these are all the elements that absolutely must be in your contract. You can put in more, but at a very minimum, these 7 or 8 items are absolutely mandatory under the Real Estate Act and as a best practice in any case. So those are the kind of the high level stuff. I had a little bit more here to talk about in terms of the duties and the duties of the manager and the duties of the corporation, but we're running tight on time. Sandy, if you want to pick up with some board motions and resolutions, and I think after that we move to the Q&A.
My comment back on the service agreement as well comes back that as with a number of motions and resolutions that are going to come before meetings, whether it's meeting of the board or meetings of the owners, it's the same. This particular service agreement, this may be one where you may want to get your lawyers involved. I appreciate lawyers are been described as English language mechanics. In some ways, that's what we are. Our skill from the solicitor's side, not the barristers, is putting those kind of written agreements together to make sure that they're clear, they're concise. And if they're not clear, then you're inviting an argument, and arguments can become very expensive. So motions, resolutions, we're getting more complicated every year. We now have things such as special levies. Even now assessing budgets has become a little bit more complicated. This may be one where you want to involve legal counsel to help you draft the resolution, to make sure you have the language correctly. As Andrews and I would both comment, if you go back 30 years, yes, it's likely the property manager was the jack of all trades, would draft it up and away you went. But unfortunately, society has changed. People have become more argumentative, and we seem to have more owners who are prepared to want to argue things. So the wording of those motions is important. If it's something other than absolutely routine, consider spending $1 or $2 and saying to your lawyer, here's what we want to accomplish. Does the wording of this motion cover it? And if it doesn't, change it. The board and the secretary of the meeting and the president of the meeting have to be aware or be made aware of different subject matters that require different kinds of motions. Sometimes an ordinary resolution is sufficient. Sometimes it's a special resolution, depending on what you're doing. And they have to know which one is which. So some education is required. If you get the wrong one, then you're going to have serious problems with it. Minutes generally, whoever's taking the minutes has to remember that the minutes are to clearly set out the issues that were resolved or decisions made at the meeting. Second is issues that were identified at the meeting and how they're going to be resolved needs to be set out clearly. And we've all seen too many minutes that are vague, that don't really tell you what was going on. And those are ones that are problems. And we've had a number of cases come before the courts where they pulled up the minutes of the meeting and there's ambiguity, it's not clear. And there were consequences in costs for not being clear. So the answer is a simple one. Make sure, get some help where you need it, and don't scrimp because it can be expensive otherwise. Okay, questions and answers.
Yeah, just a housekeeping thing there. That slide that Bev just went to is the slide that Sandy just covered in terms of motions and ordinary resolutions and special resolutions. So that was already covered. So with that, Bev, I think we can just go right to that final slide, which was the Q&A slide. And I understand that there's a couple of repeat ones. So with that, Heather.
Yes, thank you both Sandy and Andrew. So from the questions, let's go to Tim Battle first. He asked, does legislation require that a service contract has an end date? If so, what is the status of a contract without such a date?
The first part of the question, Heather?
Does legislation require an end date for the service contract?
Yes, it does. Or some means by which the contract can be ended. It doesn't have to be a specific date, but there has to be some mechanism that says it will end 30 days after notice in writing is given. Or it will end if I give notice 60 days before the end of the current contract. There's a mechanism by which it can come to an end.
And if a contract doesn't have that, what is the implication?
It likely is not a valid contract.
Okay,
Yeah,
thank you.
Yeah, I think I agree completely with Sandy on it's likely no longer a valid contract. And then I would, and again, this is perhaps the operator side of me, not the legal side of me. You know, you beg forgiveness, you don't ask permission. I would just, if you're looking at getting out of an open-ended contract, I just simply, as Sandy pointed out, say, here's our 30-day notice of our intention to terminate, and just go from there.
Okay, we've got a couple more questions coming in. So does a board have to have a president, vice president, treasurer, and secretary?
Those are best practices. And so where we see variations on a theme, it's important to have somebody to chair meetings and to be responsible. In most service agreements that we put forward, we insist that there be one single point of contact between the corporation and us so that there's not confusion in communication. So the board chair's responsibility becomes circling the wagons with his team or her team and then conveying those directives to us. So having a vice president is really, I think, is optional. It's not mandatory. The secretary, I think, is a critical role. The minute taking is important, but as Sandy's pointed out, there's so many details that need to be kept track of. That corporate secretary role is critical. And a lot of boards look at that as just, well, I'm just here to take minutes. That role is a significantly more important in governance than many people believe. And I think you need to have a treasurer. Somebody they don't have to be a CPA, a CFA, or any other designation for finance. Be a good idea if you can read a balance sheet and understand cash flow statements. Those three would be critical in my view.
Okay.
I think to the extent that that was a technical question, I believe the Act only requires a president, a secretary, and a treasurer.
Yeah.
But I'm flipping quickly through because it's not one of those things I've memorized. I think the 3 spots are there, but I don't know that it requires vice presidents. But I can look that up and afterwards.
Okay. Wonderful.
But there is a provision in the Act that does say certain officers.
Okay.
But your bylaws can provide, and you can have, as Andrew points out, you can have as many officers as you want. You can have an official dog keeper if you want. The bylaws would define what the officer is and what he's called and what his duties are. But the minimum is those three. Sorry, go ahead.
Thank you. So I think we have time for 2 more quick questions here. So can the board or property manager advance it or ask in advance the questions be submitted from unit owners so that they can decide which experts they might need to invite, if any, to the AGM?
Absolutely. Sounds like a good idea.
Yeah, we have boards that will actually undertake a review of potential Q&A items that might come up in advance based on the feedback they've received over the course of the year. The worst one I've been involved in was last year, 508 unit urban high rise. We had over 100 Q&A questions that we developed in advance of the meeting. Fortunately, we didn't have to get through all of them at the meeting, but yes, it is a good idea. And again, there's so much that goes on after the AGM once the board takes over, and not all are great at communicating to their owners and their residents what's been going on through the course of the year. So in the absence of that, it is a good idea to reach out and say, hey, are there specific things you want us to address this year?
Okay, we have a question from Kathy, and I'm just going to paraphrase here. She's trying to get a sense of what's the average number of hours that a property manager would typically expect to work in a regular non-board meeting week for a 100 to 120 suite complex.
Wow, that's a tough one. In a non-board meeting week, so very few condominium property managers will be a sited manager for a 100-door property. The economics don't really work out that well. So most property managers in Alberta right now, not all, but most, are what we call portfolio managers. Portfolio managers on average run about 10 properties. And if you've got 5 days a week, that means you've got 2 half days or a half day per property. So I would say an 100-door unit in a week. Now, this is also assuming that you've got good administrative support, good accounting support, you've got good corporate services support, and that's all behind the scenes stuff to take care of mailing and reception, and you've got a good portal where there's access to information, et cetera. I'd say per property, 4 to 6 hours per week, per property.
But that really depends on whether it's a high-rise building, whether it's a townhouse building, whether it's right beside the university and full of university students, as opposed to a retirement community.
And
add variation.
And add to it that if the bulk of your building are absentee owners and they run it as Airbnb or as rental, it adds a whole other dynamic to it. It's a great question. I think, Heather, we could do an entire webinar just on that question.
Maybe we'll have to do that in the future.
Yeah.
Doug Dixon from RECA did get a chance to flip through the CPA regs, and section 11 outlines the officers required at minimum being the president, vice president, secretary, and treasurer. So with that, I think we're going to have to wrap up as we are pushing past our timeline here. We really appreciate the attention and the questions from all of our attendees today. And I know we would all like to extend a huge thank you to Andrew and Sandy for sharing their expertise. I wanted to remind you that a recording of this session will be posted, and you'll receive the link via email along with copies of our resources. If you have further comments or questions about today's session, please include your email address and those comments or questions when you fill out the event survey so that we can follow up. Thank you again to the Alberta Real Estate Foundation, who made this series possible with their generous support. Find out more at arif.ab.ca. And again, if you liked this webinar, please remember to register for the next one in the ACMEC Summer Series, which is Things to Know for Self-Managed Condos, that we are hosting on August 9th at noon. Have a great rest of your afternoon, and we'll see you at the next session.